Good morning, everyone. Welcome. Thanks for joining us this morning. We'll just give everybody a couple of moments to enter the room, and then we'll get things underway. All right, I can see people are starting to arrive now, so we'll get things started. Thank you again for joining us. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock, Pitman Legal, and thank you again for joining us for our webinar today on testamentary trusts. Before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located. We pay our respects to their elders past, present and emerging, and we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. I know many, many of you have attended our webinars before, so welcome back. If it's your first time, then a very special welcome. And we hope these webinars are just a helpful resource for us to share with you some of the things that we're seeing in our day-to-day practice, also things that are emerging, things that we think are beneficial for you to know about. You do have all of the recordings of our webinars on our website, and you can find them on our resources page. Our lawyers have done webinars, as you may know, on obviously wills and estates, the theme for today, but also commercial law, property law, disputes and litigation, and so on. But today we're talking about testamentary trusts, and it's something we find our clients often will have heard about, but rarely is there a really good understanding of how they work out there in the general community. There are some really beneficial features of testamentary trusts, of course, particularly for the beneficiaries, and that's why they should be considered in a lot of cases. So I'm joined today by Vinay Prasad from our team here at Sharrock Pitman. Vinay is a senior associate and accredited specialist in wills and estates law, accredited by the Law Institute of Victoria, and he's also a member of STEP, the Society for Trust and Estate Practitioners. Vinay and I both do a lot of work in this estate planning space. I know he's really looking forward to sharing his guidance with you today. Before I begin, I will just run through a couple of housekeeping items. We are recording the session and it will be available on the website soon, and afterwards we'll send you a link. So don't worry if you miss anything. You're obviously welcome to contact us afterwards, but the recording will be available. If you have any questions throughout the session, please feel free to type away in the chat box. We'll try to get to them throughout the session and also at the end, but we are conscious of everybody's time. So if we do run out of time, don't worry, we'll keep track of your questions and try to get back to you afterwards. Before I hand over to Vinay, we are lawyers after all, so forgive us for some fine print. Needless to say, we can only give some general information in this session. Everybody's situation is different. Everyone's family and asset situations are different, and laws relating to wills are Victorian-based and state-based around the country. A lot of what we're going to talk about is around the tax planning benefits of testamentary trusts. So obviously that's a federal thing, but do keep in mind that we are here in Victoria and speaking from that perspective. So with that, any further ado, I will hand over to Vinay. Thanks, Vinay.
Thanks, Mitchell, and thanks everyone for joining our webinar today. So just to give you an overview of what we're going to discuss today, we're just going to start by just an explanation about what is a testamentary trust will, because a lot of you might not exactly know what that is. And then we'll move into some of the benefits that a testamentary trust will can provide, so the tax planning benefits that it can provide to your beneficiaries in the will, and also asset protection for beneficiaries from things like family law claims or claims from creditors. And then we'll move into discussing are there any disadvantages of testamentary trust will? In my view, there aren't any, but we'll cover that. And then also discussing whether a testamentary trust will might be the right fit for you. All right, so let's get straight into it. What is a testamentary trust will? So in effect, a testamentary trust will is a will you establish for the benefit of your beneficiaries after you've passed away. So what it does is in your will, you will specify that on your death, your beneficiaries can receive their inheritance through what's called a testamentary trust. And it can provide some tax planning benefits for that beneficiary and also some asset protection benefits. And I think the easiest or the simplest way to kind of explain testamentary trust wills is to compare them to what's called what we call like a basic will. So this is kind of like a basic will is like your stock standard will. You can get those do-it-yourself kits from the post office, which we don't recommend. But if you do, this is the type of will you'll get. So then on your death, you can see in the diagram there, you'll leave behind your assets, which form part of your estate, and then your will would say that those assets just go directly to your beneficiaries. So pretty straightforward. The benefits of a basic will, it's very simple, can be done at quite a low cost and easy to understand for your beneficiaries, but there are some risks in a basic will. Firstly, your beneficiaries might end up paying more tax. There's no inheritance tax in Australia, but we're talking about if the beneficiary receives their inheritance and decides to invest their inheritance, then if they've received it directly into their name and they're on a high income, they might pay more tax on that invested inheritance. And then the other risk of a basic will is when the beneficiary receives their inheritance directly into their name, there's no asset protection for that inheritance. So if the beneficiary receives their inheritance and then separates from their spouse or partner, then the inheritance is at risk from a family law claim. And also if the beneficiary is going through financial difficulties or perhaps bankruptcy, because all the inheritance is in their name, it's at risk from claims from creditors. So moving on to what a testamentary trust will is. So it allows, so rather than the beneficiary having to receive the inheritance directly into their name, it allows the beneficiary to receive their inheritance in what's called a testamentary trust. And we will be getting into some kind of real life examples because I know what I'm talking about at the moment is perhaps a bit abstract. But just moving on. So the beneficiary can receive their inheritance into a trust. They control their trust and will choose which of their family members will benefit from the trust. And it's generally optional. So if the beneficiary doesn't want this trust, they can just elect to receive their inheritance directly into their name. And it operates in the same way as a basic will. But if they want to take advantage of the trust, then the option's there. They can receive the inheritance into the trust and it can provide some tax planning and asset protection benefits, which we'll get onto. And that this is just a diagram of how a testamentary trust will would work. So the deceased passes away, they leave assets which form part of their estate. And this is an example where the deceased has two children. So each child receives 50% of the estate, but they receive it through a testamentary trust. So each child controls their 50% share in their trust, but the trust has a number of beneficiaries, including that child, their spouse, and their grandchildren, just meaning that the child or the primary beneficiary can split income and capital to those other members of their family. So one of the main advantages of a testamentary trust will is the tax planning benefit. So the beneficiaries receive their inheritance into that trust, the testamentary trust, and they, as the trustee, can distribute income amongst their spouse and children, including minor children and grandchildren. This can lower the overall tax bill. Sorry, I should mention, so they receive the inheritance and they decide to invest that inheritance. The inheritance is earning an income through the trust. They can lower the tax by allocating income earned from that inheritance between different family members on different tax brackets, which can lower the overall tax that's ultimately paid on that inheritance. Some of you might be aware if you have a family trust or deal with family trusts. Generally, if you distribute income to minor children, those distributions are taxed at approximately 45%. But there's an exception in the tax legislation for testamentary trusts. So if you've got a testamentary trust and you're distributing income to minor children, each of those minor children get an $18,200 tax-free threshold, plus any further applicable tax offsets, which can be really beneficial in reducing the tax payable. So moving on to some examples, which hopefully will make it a bit easier to understand. So I've come up with this fictional scenario here. So you've got Derek and Margaret. They're both aged in their 70s. They've got one adult daughter, Monica. So Monica's an engineer. and she's on a high income, earning about $195,000 a year, and Monica has children of her own. So Derek and Margaret make their wills, just pretty what you'd expect. On their death, just everything goes to the surviving spouse. And then after they're both died, everything goes to Monica. So Derek dies first, followed by Margaret, and then on Margaret's death, the estate's worth $900,000. So we'll take you through some different scenarios here. So let's say, for instance, Derek and Margaret did a basic will. So Monica inherits the $900,000 directly into her name. She's got no other option. She has to receive it directly into her name. She uses those funds to purchase an investment property, which earns $25,000 in rental income a year. And because Monica's on a high income in the highest income tax bracket, the income's taxed at 40. The income on that, the rental income on that investment property is taxed at 47%. And then further, if Monica later sells the property, then any capital gains tax that she has to pay is assessed on her income and take into consideration the fact that she's in the highest income tax bracket, which could mean that she ends up paying a lot of tax. So now we'll move on to a testamentary trust will. So if Derek and Margaret had set up a testamentary trust will for Monica, this is how it would work. So Monica receives a $900,000 inheritance into her testamentary trust. Monica's the trustee of that trust, so she controls the inheritance in that trust. But her children, the way Margaret and Derek drafted their wills, Monica's children are also beneficiaries of that testamentary trust. So again, Monica uses that inheritance in the testamentary trust to purchase an investment property, and it earns $25,000 in rental income a year. So this is the tax. I'll move on to now in the next slide, the tax saving benefits potentially for Monica. So Monica is the trustee. The rental income earned from that property that's in the trust can be allocated not just to Monica, but to her children as well, because they're also beneficiaries of the trust. So Monica allocates the rental income to her children to pay for their school fees, medical fees, and dental fees. Because each child receives a tax-free threshold of $18,200, effectively no tax is paid. Because if you're getting it's earning $25,000 a year. Let's say, so the property, let's say Monica's got two children. Each of those children get an $18,200 tax-free threshold. So in effect, you can distribute the income to the children and no tax is going to be paid. So the estimated tax savings for Monica, $11,750 each year. And just bearing in mind, these are kind of estimated figures only, and they're based on current taxation rates. But obviously, we recommend you get advice from a qualified accountant, a tax accountant as well. If Monica later sells the property, then the capital gain can be, the tax can be split, the capital gain can be split amongst herself and her children to also reduce the capital gains tax liability potentially. Moving on to another example. So this is a couple with young children. So Nicole and Jane, they're married with two young children. Nicole's an occupational therapist. Jane, she works part-time as a psychologist, earning about $70,000 a year. So they do the wills, just leaving everything on the death of one, just everything goes to the surviving spouse. And sorry, I should have mentioned, I don't think I put it on the slides there, but tragically, Nicole passes away in a, sorry, Mitchell, there might be a missing slide there, but yeah, no, let's just stick with that. Sorry, that seems to be a missing slide there. Apologies for that. But anyway, so Nicole tragically passes away in a car accident. On Nicole's and Jane inherits $500,000 from Nicole's estate, and this is after she's paid off the mortgage. She's left with $500,000. So if Nicole had done a basic will, Jane would receive $500,000 into her name. She puts the funds in a term deposit, and the funds earn $20,000 a year in interest. Jane continues to work, and so the interest increases. The interest on that term deposit increases Jane's taxable income, and she ends up paying 32% tax on that interest. But if Nicole had done a testamentary trust will, so Jane directs the $500,000 she received from Nicole's estate into that testamentary trust. Jane is the trustee, so she controls her testamentary trust, and her children are also beneficiaries of the testamentary trust. So what happens now is, so Jane again puts the funds in a term deposit, earning $20,000 in interest. Jane, as the trustee, controls the trust, and she allocates the interest earned from that term deposit to pay for a part-time nanny for her children. Because each child receives a tax-free threshold of $18,200 per year, effectively no tax is paid on the interest earned on that term deposit. So the estimated tax savings for Jane, $6,400 each year. All right, so that's kind of a summary of the tax planning benefits of testamentary trust wills. Now we're going to move into the other main advantage of testamentary trust wills, which is provide some asset protection for your beneficiaries. So if you give your beneficiary the option of receiving their inheritance through a testamentary trust, it can provide a level of protection if that beneficiary is going through family law separation. And it can also provide some protection if the beneficiaries going through some financial problems and is facing claims by creditors or perhaps even bankruptcy. So generally speaking, the less control you give a beneficiary over their testamentary trust, the less effective it is in protecting the inheritance against a claim by an ex-spouse or creditors. And it's always a careful balancing act. You know, you don't want to restrict the beneficiary's control too much, but you also want to give them a level of asset protection, and that's what an estate planning lawyer can guide you through. But we'll move into some examples of how this can work in practice. So firstly, family law claims. If beneficiaries separating, then testamentary trusts can protect the inheritance from a family law claim. So here's an example. So we've got Paul and Vicky, both in their 60s. They've got 3 adult children, Katrina, James, and Amy. So Katrina has a rocky relationship with her partner, Vincent. Paul and Vicky's assets are worth $2 million. They do, in their wills, they do what you'd expect, leaving everything to each other. And then after they've both died, everything equally between the 3 children. So Paul dies first, followed by Vicky. So that's leaving behind a $2 million estate. And at the time of Vicky's death, Katrina and Vincent, unfortunately, are separating. So this is how a basic will could work. So this is where Katrina has to receive her 1/3 share directly into her name. Forms part of the family, what's called the family law asset pool, and means that goes into that pool of assets, and Vincent can make a claim on that inheritance as part of the family law assets in a family law claim. But in contrast, if Paul and Vicky had set up testamentary trust wills for Katrina, this is how it could work. So Vicky's will, you know, Vicky died last, we'll remember. So Vicky's will directs that Katrina's 1/3 share goes into a mandatory testamentary trust. So it's not optional. She has to receive it through a testamentary trust. Katrina's a beneficiary of that trust along with her children, but she's not the trust. The will says that she's not the trustee of that trust. Her siblings are the trustees of that trust. So her siblings control the trust, but Katrina's got no control over the trust, but she is a beneficiary of that trust. So because Katrina has no control over the inheritance, it becomes more difficult for Vincent to be able to claim that inheritance in a family law claim. It's not always 100% effective. The family courts do have a lot of power, but it will make it more difficult. It will make it easier for Katrina to claim my inheritance should be kept separate from the other assets. But what also could happen is that the court could have a look, the family court could have a look at this and say, okay, we won't touch Katrina's inheritance, but we'll give Vincent more of the other assets of the marriage. But in any event, if it's important to Paul and Vicky to protect the inheritance from a claim by Vincent, then a testamentary trust can be useful in providing a level of protection. Well, sorry, this is what I was saying before. Not, protecting against family law claims isn't always 100% bulletproof. Each case is decided by the court on its individual facts. but a testamentary trust will offer more protection than a standard will. And the other downside is, as we mentioned, because Katrina is not the trustee of her testamentary trust, it does place a lot of trust in her siblings that they're going to manage the trust properly for Katrina's benefit, and that Katrina can work with her siblings to manage her inheritance. So that's another potential downside, and it's important to consider all this before deciding what kind of testamentary trust will you want to put in place. Now we'll move into and so another protection, another type of protection that testamentary trust wills can provide is protections from a second spouse. So we'll go back to the example of Nicole and Jane that I was using previously. So you might recall, young family, 2 young children. Nicole passes away tragically, uh, leaving an inheritance for Jane. So some years after Nicole's death, Jane repartners. So if Jane, say Nicole had just set up a basic will and Jane just received the inheritance into her name, and then she repartners. If she separated from that partner, then the inheritance that came from Nicole might be at risk from a family law claim. And also, if let's hope this would never happen, but if Jane also died, then that inheritance could be at risk from a claim by Jane's new partner as well. Whereas if Nicole had set up a testamentary trust in her will and allowed Jane to receive her inheritance through a testamentary trust, then if Jane repartners, it can provide some additional protection from a family law claim if Jane separates from that partner, or if Jane passes away, it provides some protection as well, meaning that there's a greater chance that the inheritance will eventually flow to the children rather than being claimed by any subsequent partner of Jane. The other type of asset protection that a testamentary trust will can provide is protection from bankruptcy and creditors. So, if you're a testator, if you're a will maker and you've got adult children and perhaps they work in high risk industries like a surgeon, or they run their own business, just any type of occupation where they might be at a greater risk of being sued for negligence or other types of claims, or perhaps if the beneficiary hasn't made the best financial decisions and is facing bankruptcy, then a testamentary trust will can actually be very effective in protecting an inheritance from claims by creditors. So we'll use just to give an example, we'll use the example of Paul and Vicky that we were using before. So you might remember 3 adult children, Katrina, James, and Amy, and the estate's worth about $2 million and is going to be split equally between the 3 children. So the son, James, he opens a restaurant. Unfortunately, the business fails, and at the time of Vicky's death, James is bankrupt. So this is how a basic will would work. So James has to receive his 1/3 inheritance of about $700,000 directly into his name. And because it's in his name, there's no asset protection at all. And if he's bankrupt at that time, then the bankruptcy and trustee will seize that inheritance to pay James's creditors. There's no ifs, no buts there. It will just be taken. Whereas if Paul and Vicky had set up testamentary trust wills, this is how it could work. So Vicky's will, who died last, sets up a mandatory testamentary trust for James. James is not the trustee. His siblings are the trustees. And because James has no control over his testamentary trust, his inheritance is protected from creditors. So when we were talking before about family law claims, they're not always 100% protected because the family court has a lot of powers. It's a bit different with claims by creditors and bankruptcy. The courts have every now and then have to review these types of cases, and they have time and time again pretty much said that if the inheritance is in a testamentary trust, it's pretty much 100% protected from claims by creditors. So a testamentary trust can be very effective in protecting an inheritance in these type of claims. So because James has no control over the trust, his inheritance is protected. And then after the bankruptcy ends, the siblings reappoint James as the trustee, and then he's back in control of his inheritance. So as we were talking about before with the example with Katrina, this type of situation does require some trust in James's siblings because they're going to be the trustees for that period that James is bankrupt. So, you'd have to hope that James can work with the siblings to properly manage the inheritance during that period. All right, so we quite often get asked, so what if I just do a basic will and then when my beneficiaries receive their inheritance on my death, they can just set up their own testamentary trust then? Well, the answer is no, unfortunately. Um, a testamentary trust, it's there in the name. Testamentary, um, you know, it means it has to be done in the will. And for the beneficiary to get those tax planning benefits and asset protection benefits, it needs to be set up in your will. They can't set it up after you've died. The beneficiary might, in a basic will, might receive their inheritance directly into their name and then decide to set up a family trust to um, to manage their inheritance. But that won't provide the same tax planning benefits as a testamentary trust will, because, like we were talking about before, distributions of income to minors gets taxed at about 45%. And then also, if the assets are in a family trust, there might be some asset protection there, but not for the first 5 years, because the way the bankruptcy laws work is that if the beneficiary receives the inheritance into their name, so it comes into their name and then into a family trust, then for the first 5 years, if the beneficiary faces financial difficulty, the trustee in bankruptcy can claw those assets back, that inheritance back out of the trust to pay the creditors. Whereas if you'd set up a testamentary trust in the will, it wouldn't have come to the beneficiary first. It would have just gone from your death, from your name, straight into the beneficiary's testamentary trust and would be protected from claims by the bankruptcy trustee or by creditors. So short answer is no, you can't set up a testamentary trust after you've died. It has to be established in your will. All right, so are there any disadvantages of a testamentary trust will? Well, the short answer is no. Um, Testamentary trusts are generally optional for a beneficiary. So the beneficiary can choose whether they want to receive their inheritance through the testamentary trust and take advantage of those tax planning benefits, or they could just choose to not worry about it and just receive the inheritance directly into their name. So if the beneficiary decides it's not going to be useful for them, they can usually just decide to receive it just directly into their name and not worry about the testamentary trust. Um, if the beneficiary does choose to establish a testamentary trust, then there's probably going to be some ongoing extra accounting fees, because a separate tax return needs to be prepared, and trust financial statements for that testamentary trust each year. So they'd need to see an accountant to assist them with that process. But they'd probably get the advice before they set up the testamentary trust about what the ongoing costs are likely to be, and with that in mind, is it worth using this testamentary trust? Um, but then also the other thing to consider, and this isn't so much for the beneficiary, it's for you if you're considering doing a testamentary trust will. It is quite a complex legal document for your solicitors to draft for you. It's a lot more complex than a basic will. So the cost to draft a testamentary trust will for you will generally be higher than if you were to do a basic will. But in our humble view, the additional tax planning and asset protection benefits that a testamentary trust will can provide for your beneficiaries far outweighs the initial extra upfront cost. So, is a testamentary trust will right for you? Well, testamentary trust wills can really benefit a broad range of people. You don't have to be super wealthy for your beneficiaries to be able to benefit. So, if providing asset protection for your beneficiaries is important to you, then a testamentary trust will can be very beneficial for your beneficiaries, no matter how large or small your estate's going to be, because you're saying that on my death, the beneficiaries will receive their inheritance through that testamentary trust, which can provide the protection to an extent from family law claims or claims by creditors or bankruptcy. So if this asset protection is important, then a testamentary trust will always be useful for you to provide for your beneficiaries. In terms of tax planning benefits, testamentary trust wills are usually more suitable if you have children of your own and perhaps even grandchildren. Then wealth can be passed down the generations through the testamentary trust, and income can be split between a range of those family members to lower the overall tax bill. So if you don't have children, then definitely speak to a lawyer to get some advice, but perhaps a testamentary trust won't be as beneficial from a tax planning point of view. Generally, to take advantage of those tax planning benefits, generally you need to be of kind of moderate to high wealth. But don't forget about your superannuation and life insurance, which can come into the estate as well. A lot of young people, particularly, might think that when they pass away, they're not going to have much, but they're forgetting that they might have quite a bit in life insurance, which, if the nomination's been made correctly, will come into the estate and then can form part of that testamentary trust in the will. So, yeah, but to get those tax planning benefits, generally of moderate to high wealth, um, and also to take advantage of those tax planning benefits, the beneficiary, when they receive their inheritance, they're going to want to invest that inheritance. So if you think your beneficiaries would just use those funds just to, pay off their mortgage or to perhaps just put straight into their superannuation or something like that, then perhaps they won't be able to take advantage of those tax planning benefits. But it's always worth having a discussion with your estate planning lawyer as to whether a testamentary trust would be suitable for you. And finally, uh, for your beneficiaries to benefit from a testamentary trust will, you have to have assets in your name. So, if, for example, most of your assets is in an existing family trust, which is common for some business owners and high net wealth people, um, then those assets in the family trust aren't covered by your will. They're separate estate planning documents which you need to put in place to pass control of that family trust. But it can't the assets in the family trust can't come into your testamentary trust will and to take advantage of those tax planning and asset protection benefits, generally speaking. All right, so that's pretty much the end of the webinar.
Thanks,
So
Vinay.
yeah,
Yeah.
sorry.
We do have a couple of questions that have come in.
Hmm.
Um, if the house in the estate is not sold, say there are kids who are underage and they're still living in the house with a guardian,
Hmm.
and the house is the house subject to land tax if it's held in a testamentary trust?
Um, this is a standard clause in the testamentary trust wills that we draft, but the beneficiaries have to be given a specific right to reside in the family home. So the children have to have a right to, in the will, to reside in the family home. And then provided they've got that right, then my understanding is that it is exempt from land tax for the period that the children reside in the family home. And it's also exempt from capital gains tax if the property is sold in the future.
A little bit different to a typical scenario having where you typically wouldn't have principal place of residence in a trust,
Yeah.
but different because of the estate aspect of it. And going back to the example of Katrina, who was separating from her husband Vincent, and her siblings were being made the trustees of her trust, can those trustees be changed over time?
Yeah, yeah. I mean, so it like I was it's a bit of a balancing act between providing a high level of asset protection for Katrina and providing kind of flexibility and control for Katrina. So it's a discussion you have with your estate planning lawyer, and there's no one set way to draft a testamentary trust will. It will really depend on the circumstances and what you want. But say, for instance, so yeah, usually our wills, the way we draft them, there's a position in the testamentary trust called the appointor. So that's separate to the trustee. And the appointer's got the power to remove and appoint the trustee. So you could draft it so that Katrina continues to be the appointer of her trust, and so then she can choose when the siblings are removed and when someone else or herself is appointed back as a trustee. That might reduce the asset protection because the family court might take the view that Katrina's got some control over that inheritance. Or you could appoint a third party independent person as the appointer who would have that power to remove the siblings if they're not doing the right thing by Katrina. But it's just a matter of having a discussion with your estate planning lawyer. And another position you can insert in the trust is what's called the position of a protector. So the protector doesn't have any active involvement in the trust, but their consent is required before capital can be distributed from that trust. So, say Katrina retained the role of protector, it would just mean her siblings, yet they're managing the trust and perhaps managing distributions of income and managing what type of investments are acquired through the trust, but they can't deplete the trust without Katrina's consent because she's got the position of protector. So it's just a matter of having a discussion with your estate planning lawyer about what's the most suitable for you.
And does using a testamentary trust mean that the will is protected from being challenged and contested?
No, no.
Mm.
So, because when you pass away, the assets. come into your what's called your estate first. Your will appoint an executor, and the executor is responsible for kind of calling in all the assets into your estate. And then from your estate, it's separated into the testamentary trusts. Um, but whilst assets are in your estate, a person's got, well, if we're talking about the most common type of challenge, which is called a family provision claim, a person's got 6 months after probate is granted to challenge the estate. So the short answer is no. There are other things you can do, which is a bit outside the scope of this webinar to protect your inheritance from a challenge against the will, but a testamentary trust in itself will not protect the inheritance from a challenge.
A couple of people have asked if the trustee of the testamentary trust can be a company or a corporate trustee, or
Yes,
does it have to be an individual?
no, it can be, yeah, it can definitely be a company. So um, generally well, I guess like the way, like I said, the way we draft our wills is when I was mentioning before about the position of appointer, the main child, if I can put it that way, the main beneficiary will be the appointer, and then they have the ability to appoint the trustee. So they can appoint themselves as a trustee, or they can set up a company and appoint themselves as the sole director and shareholder, and then that company is the trustee. So yeah, it can. I mean, it will depend on the terms of the will. Like so, we've seen some testamentary trust wills drafted by other law firms that are quite restrictive and don't allow a company to be a trustee, but um, provided it's allowed in the testamentary trust document, then you can definitely appoint a company.
And when does the testamentary trust start? On the date of death or on a later date?
Uh, no, well, it would start. It's an interesting question. I think it would start. I wouldn't start on the date of death. It would have to first be established. So generally, what would happen is um, so when someone passes away, the executors in the will apply for probate, call in all the assets. Once all the assets are in, all the tax and liabilities are paid, then it's split into the testamentary trust. In practice, what we usually tell a beneficiary to do is just go to the bank, provided they're the trustee, and just open up a trust account in the name of the testamentary trust, and the bank will usually require a certified copy of the probate with the will. And I'd say that's when the trust is established, when that bank account is set up. Would you say the same, Mitchell, or not?
Yeah, I
It's a bit of an
agree.
interesting question. Yeah.
Yeah, it's important to remember that everyone that the will doesn't actually create these trusts yet. They are basically providing the framework there for them to be activated by the beneficiary if they want to use the trust later on. So that usually is at a later date after the will maker has passed away. Yeah. A bit of a hypothetical in the case of a bankruptcy or family law claims and assets are protected
Hmm.
only when we can prove beneficiary does not have control of the assets in the testamentary trust and they are not the trustee. What happens when the beneficiary involved in those claims is also the trustee and has control over the assets? That would be a
Mm.
bit of a problem, wouldn't it?
Yeah, it's all a matter of degree. And no case is the same. It depends on the individual facts, and you have to separate it between family law claims and bankruptcy claims. As I was mentioning before, whether we like it or not, the family court does have a lot of power and does have a bit more power to kind of intervene into trusts. Whereas in terms of the bankruptcy or claims by creditors, the testamentary trust can provide a higher level of protection for those. There have been cases even when the person who's bankrupt is the trustee that it has been held to still be protected, particularly if they're not the trustee in their personal capacity. They've set up a company where they might be the sole director and shareholder. But with family law claims, if the beneficiary is also, sorry, the person going through the family law separation is also the trustee of their testamentary trust and they're the sole trustee, then there's a higher risk that the family court might take the view, look, this is a bit of a sham trust and it's really your assets, and so that we're going to reach into that and give some to the other spouse. I didn't touch on this in the webinar, but uh, sometimes a strategy that will market makers want to put in place, say they've got 3 children, rather than setting up a separate testamentary trust for each child, they just all their assets just go into one trust on their death, and the 3 children jointly control that trust. That can provide a bit more protection from a family law claim because it's hard for the family court to figure out how much of that global trust belongs to the child going through separation. But obviously, there are some disadvantages. The children have to work together to manage this joint trust. So it's all a matter of just considering those pros and cons.
Yeah, I can probably count on one hand the number of times we've gone ahead with global trusts, but it's definitely an option. And some families who are very close find that that's quite fine. A couple of final questions before we wrap up. Once an asset has passed to a testamentary trust, is it then protected from a claim, a family provision claim?
Uh, well, it's a bit of it. So when some, yeah, look, so when a person passes away, um, they'll have a will which appoints an executor, and like I said, the executor is responsible for applying to the court for what's called a grant of probate, which then gives them the authority to collect the deceased assets and distribute them according to the will. So, when the executor obtains that grant of probate from the court, a beneficiary has 6 months. Sorry, not a beneficiary, just a person has 6 months to challenge the will. And so, what we'd usually recommend if that the testamentary trusts aren't established within that 6 month period, because if they are established and the money goes out of the estate, it can still be clawed back if the challenge is made within that 6 month period. But after the 6 month period is expired, if then the inheritance is transferred into the testamentary trust, well, then it's no longer in the estate. The claimant's out of time to make the claim, so then at that point it becomes protected from a family provision claim.
We might just have time to run through the remaining questions. If
Sure.
anyone has any more questions, we may not be able to get to them, but feel free to contact me or Benny afterwards. Is there a separate trust deed, or is just the will that instructs it?
No, the will is
Just
the
the easy one.
trustee. So the will has to be very well drafted and very comprehensive in making sure that the trustee has all the necessary powers, and it covers situations like what happens if the trustee or the appointed dies or becomes mentally incapable, and who can take control of the trust then. It's got to be very detailed.
Yeah.
And
So the
we'll
will will
always make sure those clauses are included in the testamentary trust wills that we draft.
Yeah, so what the will looks like is basically you've got the parts that divide the estate up, and then there'll be a schedule which sets out the terms of how each trust will operate, like a mini trust deed, if you like. If there are three children and two opt to set up a trust, but one wants to receive the proceeds of the estate directly, is that okay?
Yeah, it should be. I mean, it'll depend on what the will says, but I mean, when we were talking about before, like occasionally a person might want the whole estate to go into that one global trust for the three children. Well, in that case, I mean, they could still receive their one third, but it would require some negotiation with the other two that would have to come into the trust first and then withdrawn out. Um, but if the testamentary trust will set just gives each child the option, sorry, it divides the estate into three and then gives each child the option of having their own separate testamentary trust, then one can just decide, I just want to receive my one third directly. I don't want the testamentary trust.
Yeah. It's all about giving the children the flexibility, isn't it?
Hmm.
This one might be a bit detailed for the session, but regarding the protection of initial capital, are there any other strategies to implement to protect the initial capital of the estate from being depleted? For example, can the appointer or the trustee distribute out all income and capital after 12 months, leaving nil funds? I think that might be a question about whether the trust can be wound up and income and assets distributed out of the trust.
Yeah, yeah. I mean, look, if I'm understanding the correction correctly, so yeah, the assets will come into the trust first, and then it's up to the trustee as to how long that trust is continues for. The maximum period it can continue for in Victoria is 80 years. Um, but if the trustee, who's usually the main beneficiary, just decides they want to wind it all up within 12 months and withdraw it all at that point, they can. Yeah. Is that
Mm.
the question? So, yeah.
Yes, I think so.
Yeah.
If that um, attendee would like any more sort of detail on that, feel free to get in touch afterwards. Um, the next question is probably on a lot of people's minds. How much does it cost to set up a testamentary trust will? The short answer to that is it can depend. Um, we do all our work on a fixed pricing basis, and even looking at a testamentary trust, it can vary quite a bit depending on the family situation and what's going into it. But to give a very rough guide, for a typical sort of husband and wife situation, the costs might be around the $4,000 to $5,000 mark, all up, including a couple of meetings and reviewing some material and drafting the documents. And final question is about our next webinar and what is the topic. So it will be from our commercial law team in June. So we'll share some more details about that coming up event coming weeks. That completes the questions. Thanks, Benay.
Thanks.
Um,
Uh,
we do have a lot of information on our website. So, as I mentioned, this webinar will be on the website shortly. We do have other wills and estates webinars on there that we've done in the past as well, and a lot of articles. So, Benay and the team are always publishing updates and articles about different things in this area, different developments that are coming through. And we have recently published a legal guide to testamentary trust wills, which is in PDF, and we'll distribute that to everyone after today. And it's also available in a hard copy booklet as well. So if anyone would like to have a booklet sent out to them, or if you're a professional advisor and you'd like a few copies that you can give to your team or to clients, feel free to get in touch, and we're very happy to send you some of the hard copies, or you can distribute the PDF freely as well. So that brings us to the end. Thanks everyone for joining us. We've had a really great level of interest in this webinar, which is really pleasing. And I think just shows how relevant this sort of topic is to everyone out there. So until next time, we hope you have a great day, and we'll see you then.